Bonjour, good afternoon and kia ora from New Zealand. My name is John Small and I'm an Associate Commissioner with the New Zealand Commerce Commission. This is my first time with the OECD's Competition Committee. I've taken over our New Zealand role from Dr. Jill Walker, who was my former colleague and who I'm sure you all know. Looking forward to meeting you all sometime in the future, but for now we'll have to make do with this. So my topic today is line of business restrictions, and I wanted to start by putting them in context slightly and then talk about the New Zealand experience, particularly in relation to electricity and telecommunications, and then just wrap up with a few things that I think we can draw from that experience. So as we all know, regulatory policy can help to promote competition, and so it can be a complement to competition policy. And I'd like to sort of suggest that there are really two main ways in which that can happen. One is by access regulation and the other one is by line of business restrictions. Access regulation, of course, is where the regulated firm, which would normally be a monopolist, competes downstream with the access seekers, and so you have these questions about equivalence of inputs and competitive neutrality in those terms of trade. Line of business restrictions, there's no downstream competition. The monopolist is precluded from serving those competitive markets. So it's somewhat more stark and more harsh. It's more of a structural measure. So we've used both of those systems in the electricity sector and in the telecommunications sector. So I'd just like to talk first of all about electricity. In the development of competitive electricity markets in New Zealand started back in the 90s when the dominant state-owned generator was successively split horizontally into four components. Each one of those four smaller firms had a portfolio of generation, and at the same time the national grid, the high voltage transmission network, was split away as a separate monopoly. In 1998, the government took a somewhat stronger line with the local distributors, who were typically trust-owned or community-owned utilities that owned the natural monopoly infrastructure and also retailed electricity over it. They were told to divest one or other of those functions, and most of them chose to sell their retail arms and keep the monopoly infrastructure business. So what happened in that sector was a shift of vertical integration from integrated distributor retailers to integrated generator retailers, because all the generators bought the divested retail businesses from the local distribution companies. And so we've had for a long time a very stable vertically integrated structure in electricity generation and retail with just five main players. Let me move on to telecommunications. The process was somewhat different. We had a state-owned single monopoly, fixed line and mobile business. I'm just going to talk about the fixed line sector here because that's where the monopoly issues are. We've got competitive mobile, as most places do. In the fixed line telecommunications sector, the state-owned firm was privatised with essentially no regulation. A couple of small consumer protection matters, but nothing regulatory in the wholesale space regarding how that firm interacted with other firms who wanted interconnection with it. New Zealand eventually moved away from that in 2001. We passed the Telecommunications Act that was based on an access regulation for voice services. That regime carried on for about 4 or 5 years. The major policy issue during that time was whether or not the local loops would be unbundled, and so that access seekers could put their multiplexes in telecoms exchanges, rent back bitstream services from the incumbent, and then sell data services to end users. Eventually that was mandated in 2006, and so the entrants started putting multiplexes in telecoms exchanges. Almost immediately, Telecom started cabinetising those exchanges, pushing fibre and intelligence further out into the network, which, as you can imagine, makes life a lot more difficult for an unbundling entrant, because they've got to buy more multiplexes, they've got to fit them into smaller cabinets, and the addressable market for each multiplexer is a lot smaller. These kinds of issues led to a degree of official frustration, and around the same time, of course, other countries were thinking about building fibre networks and getting on with building fibre networks. New Zealand finally got on that ball, if you like, in 2008 with a new government. New government came in and called for competitive tenders to build essentially a subsidised fibre to the home network covering 75% of the population. Now that arrangement was essentially regulation by contract, and it lasted from 2010 through to this year, which is now being handed over. This process of regulation is now being handed to the Commerce Commission. However, embedded in all those competitive contracts and all the regulation since then has been a very firm line of business restriction. These fibre networks are not allowed to provide any services above layer 2 in the standard OSI stack. And so you could think of that as a policy response to the previous experience, somewhat unhappy experience with access regulation. So now, just to wrap up, I think we can say a few things about access regulation and line of business restrictions based on the New Zealand experience. Regarding access regulation, I think there's three things here. One is that it's maybe think of it as a good start. It's politically not that difficult to do because it's obviously pro-competitive, doesn't abrogate the rights of the incumbent too drastically, and so that makes it easy to do. Secondly, it provides the process of regulation and thinking about what these terms and conditions need to be for access, give policymakers and regulators a lot of information about the business and how the industry works, and what the demand is, and all sorts of things that they didn't know about before, and that's useful for policy analysis and development down the line. And the third thing it does is it gives the incumbent an opportunity to play nice, an opportunity to cooperate with the policy intent, and that could be a valuable opportunity, particularly if there's something somewhat more severe, such as a line of business restriction, that is a potential further development of policy. So I think access regulation's got a great place. Line of business restrictions, they seem much more structural and certain and definite, but our experience is that, well, particularly in electricity, they have been weakened over time. The distributors made arguments that they should be able to invest in some generation. Those arguments were accepted. Once you've invested in generation, you've got to be able to sell the output. So although it's on a small scale, distributors' line of business restrictions have been weakened over time. In the case of fibre, there's been no actual weakening of those line of business restrictions, but there is a desire on the part of most fibre networks, I think, to get above layer 2, which is seen as somewhat restrictive. And you can think that there is actually a long way between layer 2 bitstream service and a retail service. And there may well be some functions in layer 2, layer 3 and layer 4, for example, where a network could collaborate with other companies to build some new innovative products and services. That hasn't happened yet, but I think there's pressure for it, and so therefore line of business restrictions maybe, whilst they are structural and permanent, there's pressure on them often. Okay, so that's it from me. I'm really looking forward to what else happens in this hearing. Looking forward to meeting you all in due course, and thank you very much.